Hello all, welcome to Law with Subhadra Malsan. Imagine waking up to a world where your emails, social media messages, and investment records are accessible by the government authorities, all without your explicit consent. Sounds pretty unsettling. That is the fundamental question arising from the government's recent move to grant the IT department extensive access to personal digital records, including email, social media accounts, and the financial data starting April 2026. As a lawyer, I must ask, does the state's power override an individual's right to privacy? This move, while ostensibly is aimed at tax compliance and national security, it raises serious constitutional and ethical concerns. Does it comply with the Puttasamy judgment on the right to privacy? Does it align with the Digital Personal Data Protection Act? And most importantly, does it respect the Articles 19(1)(a) and 21 of the Indian Constitution, the pillars of free speech and privacy? Now let's examine the legal ramifications. In the Puttasamy judgment, the Supreme Court unanimously ruled that the right to privacy is a fundamental right under the Article 21. The ruling also established the triple test for privacy infringement: legality, the state must justify why access to personal data is legally warranted; necessity, the intrusion must be necessary for national security or public interest; proportionality, the extent of intrusion must not exceed what is strictly required. Now, if we apply this test to the government's proposed access to personal digital data, does it pass the threshold? The vague and broad nature of this proposal raises serious constitutional red flags. Without narrowly defined parameters, this move risks being classified as disproportionate state surveillance rather than a justified regulatory measure. The Digital Personal Data Protection Act aims to regulate the collection and processing of personal data, ensuring user consent is paramount. However, if the government agencies are granted unchecked access to private communications, does this not contradict the very essence of the Act? Consider the Section 8 of the Act, which allows exemptions of government agencies while national security exemptions exist. There must be clear procedural safeguards. Without independent oversight, the law risks being misused for mass surveillance rather than targeted security enforcement. Now, this raises a critical legal and policy question. Who watches the watchers? Without robust oversight, surveillance laws can become a dangerous precedent. In international comparisons, where does India stand? Internationally, if we look into privacy protections vary. In the European Union, the GDPR mandates strict judicial oversight before accessing private data, even for law enforcement. In the United States, the Fourth Amendment protects the citizens from unreasonable searches, but post 9/11, laws like the Patriotic Act have expanded the government surveillance. In United Kingdom, the investigatory powers grant intelligence agencies access to data but requires judicial approval. In China, the cybersecurity grants sweeping surveillance powers to the state with the minimal legal safeguards for the citizens. Where does India fit in this spectrum? Do we align with the constitutional democracies that safeguard privacy, or do we lean towards the unrestricted state surveillance? This is the defining debate of our time. Now, if we look into the legal implications, this is just not a theoretical legal issue. The unrestricted access to the digital communications creates a chilling effect on the free speech, violating Article 19(1)(a), which is the freedom of speech and expression. History shows that excessive government surveillance disproportionately impacts journalists, activists, and dissents. If citizens start self censoring their speech due to fear of state surveillance, it strikes the very core of democracy. Now, a lawyer's recommendations here is to ensure a balanced approach. The government must adopt the following safeguards. For example, judicial warrants for data access. Government agencies must obtain approval before accessing private data. The law must specify what kind of data can be accessed and under what circumstances. A privacy review board should be established to oversee the government's data requests. As well, the government must publish regular disclosures on the number and the nature of data access requests. Of course, the citizens must have the right to challenge the surveillance orders through an independent tribunal. Now, without these safeguards, this law risks becoming an unchecked instrument of mass surveillance rather than a justified security measure. So, the government's responsibility here to conclude is to protect both national security and individual rights while addressing tax fraud and cyber threats is critical. It cannot come at the cost of citizens' constitutional freedoms. India must adopt a legally sound, proportionate, and transparent approach, one that safeguards the citizens without undermining the democratic values of the Constitution which enshrines. After all, in democracy, privacy is not a privilege granted by the state, it is a right guaranteed by the Constitution. So stay informed, know your rights, and demand your transparency. I hope this video has been informative. Thank you so much for watching. Until then, bye bye.